case, People versus Monet Mudala Bay.
Grace Hydorn on behalf of the people.
Welcome back to Trial Truth, and this hearing wastes absolutely no time throwing us into chaos. Right away, you can already feel the energy in this courtroom shifting, because what should have been a straightforward misdemeanor plea starts turning into one of those painfully awkward, unpredictable exchanges where the judge is trying to maintain structure while the defendant keeps pulling the conversation sideways. And trust me, once Judge Simpson starts realizing exactly who he's dealing with here, the tone changes fast. This case centers around a disorderly drunk charge tied to a night involving alcohol, public yelling, police interaction, and behavior that clearly escalated far beyond what anybody expected. But what makes this hearing fascinating isn't just the charge itself, it's the communication breakdown happening in real time. The defendant appears casual, confused, emotional, and sometimes unintentionally confrontational, while the court is trying to carefully walk through constitutional rights, plea procedures, and sentencing conditions. And watch closely because this hearing becomes a perfect example of how judges test credibility. Every answer matters. Every interruption matters. Every joke matters. Sometimes defendants think they're helping themselves by talking more, but in court, extra talking can become a disaster very quickly. And later in this hearing, another defendant is about to learn that lesson the hard way when attitude collides directly with judicial authority.
Ready, Judge. Torshio Feaster, Assistant Public Defender on behalf of Ms. Mudala Bay. Please unmute and state your name for the record, ma'am.
Hi, it's Monet Mudala Bay.
Mudala Bay. Thank you, Judge. I have spoken to her as well as to the prosecutor's office. My understanding is there is an offer in this file for her to plead guilty to count 1 under the HIDA program with an agreement to alcohol testing, and count 2 will be dismissed, Your Honor. She'd like to do that today.
I'm sorry, she wishes to do that?
Yes, Judge.
Yes.
All right, I do need you to turn on your camera if you would.
Yeah. I just woke up, guys, but.
So it would be a plea to count 1.
Yes, Judge.
Yes.
Okay, and you said that's with alcohol screening?
Yes, Judge.
With alcohol testing or screening? I guess
Testing is what I received.
Testing, yes.
Okay, so that has to be part of any sentence. All right. All right, got it. All right, ma'am, can you please raise your right hand? You solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God.
I agree.
All right, state your name for the record.
Monet Mudala Bay.
Put your hand
All right,
down.
you can put your hand down.
I wanted to.
All right, ma'am, it is this court's understanding that you're going to plead guilty to the charge of disorderly person drunk. That is a misdemeanor punishable by up to 90 days and or a $500 fine plus court costs.
Right here is where the court is trying to slow everything down and make absolutely sure the plea is legally valid. And honestly, Judge Simpson is showing a lot of patience already because the defendant clearly isn't processing the plea procedure smoothly. The court has to establish that she understands exactly what she's pleading guilty to, what penalties she faces, and what rights she's giving up. That's not optional, that's constitutional procedure. What makes this exchange so uncomfortable is that the defendant keeps treating the hearing like a conversation instead of a formal legal process. The judge is reading the maximum penalties, trying to confirm understanding, and she repeatedly circles back, asking for clarification or responding casually. Now, to be fair, nervous defendants do this all the time. Courtrooms are intimidating. But from a judge's perspective, confusion during a guilty plea is dangerous because if the defendant later claims they didn't understand the plea, that entire conviction can become a legal issue. Notice too how the judge keeps simplifying the explanation instead of escalating frustration immediately. That's important. Courts want clean records. They want transcripts showing the defendant knowingly and voluntarily entered the plea. And when the defendant blurts out for being drunk and disorderly and resisting, you can almost feel the defense attorney internally panicking because she just added extra conduct beyond the actual plea question.
Can you repeat that last part, please?
Which last part?
Just the whole thing.
So it wasn't the last part. You need the whole thing repeated.
Yeah, I just want to be, at this point, say the whole thing. I want to be
Take the
sure.
towel off your ears and then you'll be good. That's the problem. Okay. Yeah, I know. Okay. So, You're pleading guilty to the charge of disorderly person drunk. That is a
Yes.
misdemeanor, punishable by up to 90 days in jail and or a $500 fine plus court costs. Do you understand that?
Yes.
Understanding all that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
When you say that, you want me to just say what happened, right?
You have to
Well,
say, do you plead guilty?
Oh, yes. I plead guilty for being drunk and disorderly and resisting and being a little.
He's going to ask you what happened. So hold on a second.
Oh, okay.
as soon as I advise you as to what your rights are, you're pleading guilty. Is that correct, ma'am?
Yes.
All right. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
I won't have a trial?
That's what I said. You understand that? That's
Yes.
the case?
Mm-hmm.
All right. Because you're not having a trial, you're giving up certain other rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent and not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than dismissal of count 2 to get you to plead guilty to this charge?
Yes, the first judge that I'd seen, she said she was going to give me a personal bond. I don't know if that was for the first time I
You
went to
mean the
jail.
magistrate? You didn't see a judge. You saw a magistrate the first time.
Oh, magistrate. That's what her name is?
Well, that's her title. That she was going to give you a personal bond?
Yes.
This exchange right here is exactly why judges become extremely careful the second a defendant starts casually challenging courtroom authority or speaking too loosely during a plea hearing. Now, technically, what the defendant is saying isn't some massive act of disrespect. She's trying to explain what happened with the magistrate and clarify the bond situation. But listen to the rhythm of the interaction. Judge Simpson immediately redirects the conversation because from the bench's perspective, the defendant is drifting into dangerous territory by sounding argumentative during a guilty plea. And then comes the subtle courtroom warning. Why do you want me to take that away and arrest you? That line may sound sarcastic, but underneath it is a very real reminder that bond conditions are privileges, not guarantees. Judges absolutely can revoke personal bonds if they think a defendant is becoming non-compliant or disruptive. So even though the defendant quickly backs off and says she was just letting you know, the judge is already signaling that he wants tighter control over this hearing. This is one of those courtroom moments casual viewers often underestimate. Tone matters, delivery matters, timing matters. A defendant may think they're simply explaining themselves, but judges are constantly evaluating attitude, accountability, and whether someone understands the seriousness of the proceeding.
Well, that's what's currently set. Why do you want me to take that away and arrest you and then give you a personal bond?
No, I just was letting you know that's the only thing that I.
Oh, okay.
Yeah.
It's been promised to you.
Yeah.
Okay. Anybody threaten you or coerce you in any way to get you to plead to this charge?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you're guilty of this offense?
What happens in the dark comes to light. So y'all are going to see a video. So yes.
Okay. You're right about the first part. What happens in the darkness does come to light. But I'm asking you a different question. You're pleading guilty because you believe that you're guilty of this offense?
Of being disorderly?
And drunk.
I thought disorderly was drunk.
It can be.
Well, I know I was drunk. And disorderly.
So you're pleading guilty to the charge of disorderly drunk because you believe that you are guilty of that offense.
Yes.
Thank you. On the wrong one. On the date of April 3rd, 2022, at the location of 3135 Scenic Lake Drive, Pittsfield Township, Washington County, State of Michigan. This ought to be fun. Man, what'd you do on that date that makes you think that you're guilty?
Well, I know that I don't normally drink, and I had like a premiere party because I just did a commercial. So we had some drinks, casual drinks, but I'm not like normally a drinker. So I drank them. I guess I was mixing brown and light.
Here comes the part every judge secretly dreads during plea hearings, the unnecessary storytelling phase. The court asked for a factual basis supporting the plea, meaning simple facts proving the crime occurred. But instead of concise answers, the defendant starts unpacking the entire emotional and social context of the night, and you can almost feel Judge Simpson trying to keep the train on the tracks. Now, legally, the court only needs enough information to establish the elements of disorderly conduct while intoxicated. That's it. The judge doesn't need a documentary episode about the premiere party, mixed drinks, family conflict, or emotional triggers. But defendants often do this because emotionally, they want to explain themselves rather than simply admit wrongdoing. They want the court to understand they're not a bad person, just somebody who had a bad night. And honestly, that explanation about mixing alcohol immediately stands out because the defendant is almost narrating her own regret in real time. The problem is, once you start volunteering details in court, you lose control over where the conversation goes next. Judges can interrupt, prosecutors can build on statements, and suddenly, what started as mitigation becomes evidence reinforcing the charge.
I don't know if you know that that's not a good combination. And so, yeah, I was drunk.
Okay, so what happened?
I think I got into it with a family member, and that triggered me to be upset while I was under the influence. And I felt like no one was listening to me, so I wouldn't stop yelling. And so there was one officer that was like hearing me out and just understanding like I had a lot going on. And then the other officers, I don't think they were understanding, or maybe I wasn't understanding that they were understanding, and they just wanted me to stop yelling. And so I was just still yelling with the officer. And
okay, ma'am, hold on. Let's back up a second. Where were you when all of this was happening?
Scenic Drive, outside.
You were outside.
Mhm.
Okay. And so while you were outside, and you admit you were intoxicated, correct?
Yes.
All right. And you were yelling at either police officers or other people, right? Is that correct?
Yes.
Okay. And were you yelling loud enough to disturb the peace and repose of the area around you?
Somewhat.
And other people? What do you
Somewhat. Yes.
Okay, what do you mean somewhat?
This may honestly be one of the most frustrating moments of the hearing for the judge because the defendant keeps resisting the simplest possible admissions. The court is trying to establish one basic point. Was she loud enough and disruptive enough to disturb public peace while intoxicated? Simple yes or no. But instead, every answer turns into negotiation, clarification, or pushback. And this is where viewers really need to understand something important about misdemeanor plea hearings. Judges are not debating philosophy here. They are checking legal boxes required to accept the plea. So when the defendant starts splitting hairs about whether the loudness itself was 100% the reason she was arrested, the judge immediately redirects because the issue is broader than volume alone. It's intoxication, public disturbance, arguing with officers, and refusing to stop escalating. You can also hear the patience thinning. The judge practically walks her step by step into admitting the exact conduct underlying the offense: intoxicated in public, yelling loudly, arguing with police, disturbing the peace. And finally, after multiple redirects, she admits yes, she was being disorderly.
Loud enough, but I don't think I was
Hold on a
that
second.
loud.
You were loud enough to get arrested, right?
That wasn't why I wasn't. I don't think I was. The loudness was 100% the reason I was drunk. That was the reason. But I wouldn't not stop arguing with them. but my tone was loud.
So you were arguing with the police
Yes.
in public,
Yes.
and that caused at least their peace and repose to be disturbed, correct?
Yes.
And so, and so you admit by doing all of that, you were being disorderly.
Yes.
Counsel, please say yes, but has the court complied with the court rule? And would it be proper to accept this defendant's plea?
Yes, Your Honor. I
The
believe
people
so.
are satisfied.
Sometimes it's like picking flowers, other times it's like pulling teeth. Court will accept the defendant's plea of guilty to count 1. Count 2 is dismissed. Ma'am, I'm going to refer you to probation for pre-sentence investigation and report.
Okay.
Now, there is going to be alcohol testing. Ma'am, you have said numerous times during your plea, because I'm considering doing something else, that you don't normally drink.
Yes.
So this occurred in April of this year.
Yes.
So we are now in June.
Yes.
So for this entire year, how many times would you say that you consumed alcohol?
I don't know. I'd be prior to like a couple months before that, I was already in a program that basically was like a drug program that teaches people like
Now the hearing shifts from accepting the plea into something judges care deeply about, future risk assessment. And this is where Judge Simpson starts digging into alcohol history, because he's trying to decide whether this incident was a one-time lapse in judgment or evidence of a bigger behavioral problem. The defendant repeatedly insists she doesn't normally drink, but notice how the judge keeps testing that statement instead of accepting it at face value. Why? Because judges hear minimizing language every single day. I barely drink. It only happened once. It's not normally like this. Courtrooms are flooded with those explanations. So instead of arguing emotionally, the judge narrows it mathematically. How many times did you consume alcohol since January 1st? Clean, simple, direct. And honestly, the defendant volunteering that she had recently turned 21 changes the entire tone of the conversation. Suddenly, the judge starts connecting the timeline. Newly legal drinking age in January, arrest by April. From the bench's perspective, that is not a great trajectory. That's why the court immediately escalates toward alcohol screening and assessment instead of treating this like a harmless, isolated mistake.
I don't know.
Go ahead. So,
I don't think I was drinking a lot before that incident. And I
know. Nobody ever does think they're drinking a lot. Listen, all I'm asking is from January 1st to today's date, how many times other than this time have you consumed alcohol? Just ballpark it.
A guesstimate.
Maybe 5 times.
All right.
My birthday was January 23rd. I turned 21.
Well, thank you for sharing.
So I had to take my first shot.
I didn't. Did I ask it all for the days? I just needed the number of times.
Okay.
She just turned 21 in January.
Yes.
That's why you had to have your first shot.
I mean, I didn't have to, but I'm saying I was legal,
and then
so
by
everything was okay. But
by April, you were drinking and got arrested.
Yeah.
Not a good track record. That was less than 3 months.
Yeah.
So here's what we're going to do. I'm going to refer her to probation, but I'm also referring her to Von Swartz for an alcohol screening and assessment so we can figure out the level of testing. Okay, so you got 2 things you have to do. You have to do an alcohol screening and assessment, as well as you have to report to probation. Understood?
yes. And if I have any questions on that process, who do I talk to?
Talk to your attorney, please. Not me. All right.
Okay.
So I didn't mean it that way, or maybe I did. Sentencing, July 13, 2022, 9 a.m. Bond.
That's when I have to do the testing.
No. That's when you got to come back and I impose sentence.
You have
What do
to
you
handle the testing before that. Call me and I will help you get everything
You're
set
going to
up.
have to get an alcohol screening and assessment, and you got to talk to my probation department.
At this stage, Judge Simpson is laying out what's essentially a compliance roadmap, and honestly, he sounds deeply unconvinced it's actually going to happen smoothly. The defendant now has multiple obligations stacked in front of her: probation reporting, alcohol screening, assessment requirements, and testing compliance before sentencing. Miss one of those pieces, and what started as a relatively manageable misdemeanor situation can suddenly become much worse. But listen carefully to the judge's tone, because there's something else happening underneath the instruction skepticism. He's practically predicting future non-compliance in real time. And the second the hearing ends, he openly jokes that none of this paperwork and testing is probably going to be completed before the next court date. That may sound humorous, but judges develop instincts from seeing the same patterns repeatedly. When someone appears disorganized, overly talkative, or confused during plea proceedings, courts often anticipate future procedural problems. What's wild is that the defendant herself seems genuinely overwhelmed by the process. She's asking who to contact, what steps happen first, and whether the next date is for testing or sentencing. So even though the hearing has moments of comedy, this is also a reminder of how complicated court systems feel for people with little experience navigating them.
Okay.
Call me,
And
I'll
then
help you.
come back on the 7th or on July 13th, and then I'm going to give you your sentence.
Okay.
Got it?
Yes.
Bond will continue. Thank you.
Thank you.
Thank you, Judge.
Yep. All the other cases are ready to be recalled, of course. Everything is ready now. I have a feeling, though, just curious, all of that stuff I just ordered is not going to happen. I'm just telling you. She's going to get here on July 13th. There's nothing going to be ready. And I'm going to invite everybody back because we're going to hear a long story about why it didn't happen. Just saying. Yeah, you got to be Feaster. Torchio.
I'm here.
Do not put that case on Miss Kleeman. You need to come back and deal with that case yourself.
Okay, I'll be
Because
back.
I think everything that just happened
It's my fault.
and the minutes in my life I don't get back are all your
It's
fault.
my fault, Judge.
Just saying.
I'm
Okay.
sorry. I take
Just
sole responsibility.
Yeah, I know. And even if you don't, I'm holding you responsible.
Thank you, Judge. Sorry.
This little exchange right here perfectly captures Judge Simpson's courtroom personality. He mixes sarcasm, humor, irritation, and authority all in the same breath. The attorney jokingly apologizes for wasting the judge's time, and the judge immediately fires back that even if the attorney doesn't accept responsibility, he's assigning it anyway. Everybody laughs a little, but make no mistake, courtroom scheduling chaos genuinely frustrates judges. And honestly, moments like this matter more than people realize because they show how much courtrooms run on efficiency. Every delay, every incomplete filing, every missing report, every unresolved discovery issue pushes dozens of other cases backward too. Judges manage massive calendars, and when one case becomes disorganized, the ripple effect spreads everywhere. But what viewers probably don't expect is how quickly the atmosphere is about to change. Up until now, this hearing has mostly been awkward, messy, and comedic. That's about to end immediately once the next defendant starts challenging the judge's authority with visible attitude. And this is where courtroom viewers get a brutal reminder that some judges will tolerate confusion, but they absolutely will not tolerate disrespect. The upcoming interaction escalates unbelievably fast. One wrong response turns into contempt, then another response makes it worse. And within seconds, a defendant who probably thought he was just talking back ends up stacking jail time directly in front of the court.
Your name, sir?
Vincent Lambert.
Thank you.
Set their PCC. At this time, there's no offer for my client, so we would request to waive and seek an offer of service.
He's waiving his right to preliminary examination.
That's correct.
Is that right, sir? So you're waiving your right to a preliminary examination?
I guess so.
Well,
Yes, Your Honor.
you know what you're doing, sir?
Yes, I do. I don't know why my answer had to be so direct, but yes, I am.
Why what? Why what has to be so direct?
Why my answers have to be so direct, but yes, I am waiving my right for a preliminary.
You know what? You better check your attitude with me.
Answering your question, sir.
You can go back. I'll see him in a minute. Mr. Belvisi, check your client. Because not to. Oh, wow. Okay, bring it back here. You're in contempt. That's 30 days. You got anything else to say?
And there it is, the exact moment the hearing detonates. What started as a routine waiver discussion suddenly turns into a direct confrontation between defendant and Judge Simpson wastes absolutely zero time asserting control. Now, legally speaking, contempt of court is the judge's tool for punishing behavior that disrupts courtroom authority or proceedings. And from the judge's perspective, this defendant crossed the line by openly challenging the court's tone and attitude during questioning. The problem for defendants is that contempt decisions happen fast. There's no slow, dramatic buildup. Judges see disrespect, they react immediately, and suddenly someone is staring at jail time before they even fully process what happened. What's fascinating here is how quickly the defendant realizes the situation is spiraling. At first, he's pushing back conversationally, asking why answers need to be so direct, but then the judge interprets the attitude itself as defiance. Seconds later, the defendant is being taken away and warned he could receive another 30 days if he keeps talking. And honestly, viewers debate moments like this constantly. Some people think judges overreact to disrespect. Others believe courtroom authority has to be protected immediately, or proceedings collapse into chaos.
Anything else you want to tell me?
You guys are just like.
Anything else you want to tell me?
Yes, I do.
What? You better watch your mouth because you're going to get another 30. You're going to get another 30. What else do you want to tell me?
Nothing at this time, Your Honor.
Thank you. You are on your way out. We'll bring him back later, maybe.
That it? That's that block? What's my next block? 1 o'clock?
Yeah. Oh, except for.
I was ready to go.
Are you recalling?
Who? Your neighbor?
It's not. I don't know what I did.
No. Did you say who am I recalling?
Lambert.
Oh, Lambert. I thought you said I thought she said, will you be my neighbor? I'm like, no. Oh, hello. Oh my goodness. How are you? I'm okay. They've all been treating me badly. Mr. Balbisi? Your client? So he's got his 30 days contempt. We had him taken back down. He's not coming back up. I'll just adjourn this out. You can let him go.
Your Honor, he does have another CC tonight.
Does he? Oh.
So if we want to go all together.
Oh. What's that charge?
It's possession of that.
Oh. Now, plot thickens explains a lot. It's so he said on May 9th on those? Because I was just going to put this one out till after his contempt is served.
This is one of those classic courtroom moments where new information suddenly reframes everything that just happened. The second the attorney references additional charges and dates connected to the defendant, you can almost hear Judge Simpson mentally recalculating the situation. Earlier, the defendant's behavior looked purely disrespectful and confrontational, but now the court is piecing together a broader picture involving ongoing legal trouble and prior incidents. And notice how the judge immediately shifts into strategic management mode. Instead of forcing the issue further right now, he adjourns the matter out to another date and basically says, we'll see how he behaves after serving the contempt time. That's important because courts constantly evaluate conduct over time, not just isolated moments. A defendant's behavior during hearings can influence everything from bond decisions to credibility assessments later in the case. What also stands out here is the courtroom fatigue setting in. The judge sounds exhausted by the constant disruptions, confusion, and personality clashes happening across these hearings. Yet despite all the chaos, the court still has to continue processing cases methodically, making scheduling decisions, handling discovery disputes, and keeping proceedings moving forward.
Yeah, he said I may not just that one. Or that five. That's five.
Okay, so what I'll do is I'll just adjourn these out to June 6th. And then we'll see how he acts on May 9th, and we'll figure it out from there. Welcome. All right, what are we doing on this case?
Judge, I'm asking for a last PCC. I did have communication with the prosecutor who appeared on the case last time. We ordered some extra discovery, that being body-worn camera and surveillance camera video. We did receive it, but not all of it, to my understanding. We were only provided with 2 minutes of body-worn camera. So I'm renewing the request. I would also ask if you would sign a discovery order, Judge.
Would there be a need for me to sign a discovery order?
I believe at this point there would be, Judge.
Why?
This is the second time we've requested the materials for the case and still have not received them.
You, go ahead.
I was just going to say, defense counsel thinks that it's an appropriate time to request an order. She should be filing a motion. The facts are, we have complied with the request. We have gone out, requested the video, and I'm going to follow up with it again today. I mean, it's an ongoing process.
Well, here's what I understand. Please correct me if I'm wrong. You requested a different additional video, which is body cam.
And surveillance camera. That's correct.
Okay. They provided that, but you don't think that the people provided what was given to them to you.
Correct.
And then you don't think it was everything, and so now you want an order.
Yes.
That makes no sense to me. It would seem to me that they've been cooperative, and if you think that something's missing, they've agreed to follow up on it.
This exchange is actually a really important look at how discovery disputes work in real courtrooms. The defense attorney is frustrated because she believes critical video evidence is still missing, specifically additional body camera and surveillance footage. Meanwhile, the prosecutor is saying they already provided what they received and are continuing to follow up, and Judge Simpson's reaction basically comes down to one thing: cooperation matters. From the judge's perspective, issuing a discovery order right now doesn't make much sense because the prosecution hasn't outright refused disclosure. They're actively responding and communicating. So instead of immediately forcing compliance through a court order, the judge tells the defense that if they truly believe discovery violations are occurring, the proper legal step would be filing a formal motion. And honestly, this is where courtroom reality differs from TV drama. Discovery fights are often procedural, repetitive, and extremely technical. Attorneys ask for evidence, prosecutors retrieve records from agencies, footage gets delayed, files arrive incomplete, and courts have to determine whether anyone is acting in bad faith. It's less dramatic shouting and more legal chess mixed with logistical headaches.
Okay.
So, no, you don't get an order. And yeah, you would have to file a motion, but good luck with that under these circumstances. So, how much more time did you need to check into them as Hughes to try and determine?
I will check in today, and I will let the defense counsel know all the responses that I get. So if we could do at least 2 weeks to make sure I follow up.
Probable cause conference, May 23rd, 2024. 9 a.m. as your invite indicates. Bond at this time will continue. Thank you.
Thank you, Judge.
Court calls the case, People versus Anaya Haley.
Assistant prosecutor,
Good afternoon, Your Honor. Wendy Barnwell, P42505, on behalf of Miss Anaya Haley. She's also present on Zoom.
All right. Ms. Haley, can you state your name?
Anaya Haley.
Thank you.
You're welcome.
All right. What are you doing on this case?
Yes, Judge. I did receive discovery, both electronic and paper. So we're ready to set an...
You want an order too?
No, Judge,
no, never
not
mind.
at all.
Never mind, my
it.
bad. Never mind.
Have a lot of it. A lot of discovery.
Okay.
But there's one thing I want to address.
Yes, ma'am.
I know that she would have to go somewhere else, perhaps in family court. The complaining witness has her child. He is perhaps is the biological father. However, he's not the legal father at all. His name is not on the birth certificate. And this is a young child. I believe that he does not have an appropriate house. He does not have a legal right to that child unless he files a paternity action. And she needs her child. She does not have her toddler child. Or did you, since I last spoke to you, Anaya? Do you have the kid?
No, I haven't had my baby since April 19th.
Have not?
I have not.
Your Honor, it's my understanding that CPS ordered the child to remain with the victim.
Oh. Did you
And
hear
when they
that,
call
counsel?
yes, when they call CPS has no record of it. The police were supposed to call CPS, they don't. He doesn't have a legal right to the child. So because there's a case which they're not aware of, they weren't witnessing what was happening. They saw something that they interpreted a certain way. But, Your Honor, she does not have her child. He does not have a legal right to that child. He can't just take that child. And they can't just give that child, but they can't find the child. There's no arrangement for court for the child. There's nothing. She has no idea where her toddler child is.
Okay, so what would you like me to do?
All right. So I know that this is not family court. However, this.
Yeah, I know, but it felt like it there for a minute and I was about to run.
I know.
This part of the hearing suddenly becomes incredibly emotional because now we're no longer just talking about criminal procedure, we're talking about a missing child situation tangled inside an active criminal case. And even Judge Simpson immediately recognizes how messy this becomes jurisdictionally. The defense attorney is essentially arguing that the complaining witness took the child despite lacking formal legal parental status. CPS apparently has no clear record of involvement, and the mother now claims she has no idea where her toddler is. That is an explosive combination of criminal allegations, custody confusion, and emergency family concerns all colliding at once. And you can actually hear the judge catching himself emotionally for a second when he jokes that the hearing suddenly started feeling like family court. Because technically, he's right, this issue doesn't neatly belong inside the criminal proceeding. But at the same time, no judge wants to ignore a parent standing in court saying they cannot locate their child. What makes this especially tense is the procedural gap. Family court processes take time. Paternity rights matter legally. CPS involvement matters legally. Emergency custody orders matter legally. But emotionally, none of those legal timelines matter to a mother saying she wants her toddler back immediately.
I know, Judge. I know. But, you know, I need like good faith efforts to be made. And furthermore, I didn't hear who the prosecutor was because she's in the courtroom and it's hard to hear on Zoom. So I could like at least communicate with
Miss
her.
Morgan Barroso.
Okay. All right. So I'll try and communicate with her. Try and see, you know. I know family court is a very long drawn out process, but she needs her kid ASAP. Thank you, Judge. So we'll just set an exam date now.
You have all your discovery?
I do. I have a lot of electronic as well as paper.
All right. And would the people have their witnesses available the 14th?
We'll do our best, Your
Honor. You said May 14th.
You can't do May 14th?
I could do it in the afternoon, Judge.
Well, I can't. I can only set it in the morning. What about
Okay,
the following
Judge, so,
week?
You know what? I will, one split second. I was going to see, I think I can get that judge to, you know, I can, the following week, I'll do it on May 14th and I'll zoom into the other judge.
Okay.
He's pretty flexible, so.
Preliminary examination in person, May 14th, 2024, 9 a.m. That is before Judge Judge Burke.
Would it be in the same building as you, Judge?
Yes, ma'am.
Okay, Judge Burke.
He'll probably actually be in my courtroom.
Okay.
Well, no, he won't. He'll be next door.
Thank you so much.
Thank you. Bond
Thank you
continued.
very much. Thank you. Have a good day, everybody. We can leave the Zoom, Anaya.
Bye-bye.
And just like that, after all the confusion, tension, sarcasm, contempt rulings, discovery disputes, and emotional testimony, the court finally winds down for the day. But this hearing honestly gave us a full-spectrum look at what modern courtroom reality actually feels like. Not polished television drama, real courtroom unpredictability. We saw defendants struggling to communicate clearly under pressure. We saw a judge balancing patience with authority. We saw how guilty pleas require exact legal procedures, how discovery disputes slowly shape criminal cases behind the scenes, and how quickly courtroom behavior can spiral into contempt when emotions take over. And perhaps most importantly, we saw how legal systems constantly intersect with real human problems, addiction concerns, emotional instability, family disputes, missing children, and people trying to navigate processes they barely understand. Judge Simpson's rulings throughout this session stayed focused on courtroom structure and accountability. The guilty plea was accepted, count 2 was dismissed, alcohol assessment and probation requirements were imposed, discovery disputes were pushed toward formal motion practice, and contempt sanctions were used to immediately address perceived disrespect toward the court. Whether viewers agree with every decision or not, the hearing showed exactly how much authority and discretion judges hold in managing courtroom order. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.